I am not able to hear you.
Now you can hear me?
Yes,
Yeah,
absolutely.
now I am unmuted.
Yes, you are unmuted now. Right at 6:30. That is very, very good. Okay, good evening, everybody. It gives me hello. Good evening, everybody. I feel privileged to be here today and speak with you about the AOR examination on advocacy and professional ethics, as you all know. I welcome you all, as I personally feel that you have chosen to write this exam, and perhaps many of you would know that I was also an advocate on record for almost 20 years. And it is only thereafter that I was designated as a senior advocate. But when we started our journey and also to write the exam, things were very different. Those were different times. But if you have to practice in Supreme Court, then according to me, to write this exam and become an advocate on record, in my opinion, is a must. You, after writing this exam, even now, you are all advocates. You will definitely join in the journey of developing the institution of the Supreme Court. And we all know how important it is and what role India and the Indian Supreme Court is playing in the world. I am a first generation lawyer, and I feel I am very fortunate also to have entered this profession. How the lawyers should conduct themselves basically is the theme of this paper. In my opinion, I will first talk on what is that an advocate, a successful advocate, needs to do, or how he should carry himself. Ethics, according to me, professional ethics are basically is living by your conscience. In my opinion, ethics is nothing but living by your conscience. It is also very important. At the outset, I want to also mention that although this paper of ethics may seem something to do with which we daily do not in our professional career come across the rules and regulations which are enshrined in various statutes and rules, and we don't pay too much attention during the course of our practice, but we all know the importance of these rules, regulations, as how we conduct ourselves in the profession is of utmost importance. Now, we all have joined this profession and we all want to grow in the profession. But according to me, simply growing in the profession or having more wherewithal or having more materialistic things may maybe also maybe known as that it's a growth, you have grown in the profession. But according to me, growth without ethics, and ethics which is discipline and honesty and following the norms, can only mean progress. So if you want to progress, growth must be coupled with ethics. And then growth plus ethics, which is equal to progress. And progress, according to me, is something which you all achieve success, through which you achieve success, comes when you develop morality, spirituality, and humanity. That is how you achieve the whole success. Now, one very important feature right in the beginning of your career is that actually today we are in a race. But let me tell you quite clearly that this race that you have begun is like a marathon. It is not a sprint. It is not a 100 meters race which you can get over in a few seconds. It's like a marathon and will continue probably for the rest of your career. One of the most important things for advocates is that throughout your career, as I said, you have to live by your conscience. You are your own judge. Of course, there are people who are judging you all around, but the most important burden that is cast on is you yourself. Now, if you look around you, people have different opinions about lawyers, whether lawyers exploit clients or clients exploit lawyers. These are all, things which you will come across. But once you are steady and you have your feet on the ground, it is absolutely clear that you will sail through quite easily. I also feel that at the outset, I should bring to your notice a few lines from some very important judgments which will bring out clearly as to what is the purpose of ethics and how you should conduct yourself in this noble profession. Therefore, please allow me at the outset to also quote from a judgment of the Supreme Court which was delivered in 1979 in the case of V.C. Rangadurai versus D. Gopalan, in which Justice Krishna Iyer, who doesn't know Justice Krishna Iyer, in his beautiful style that he had, how he had, in a very short passage, described our profession and what we should be doing while we go through it. Let me quote from para 5 of his judgment in this case. Law's nobility as a profession lasts only so long as the members maintain their commitment to integrity and service to the community. Indeed, the monopoly conferred on the legal profession by the parliament is coupled with a responsibility towards the people, especially the poor. Viewed from this angle, every delinquent who deceives his common client deserves to be frowned upon. How beautifully Justice Krishna here, in this small passage, has described our profession and how the members of our profession have to carry out their duties. Yet, in another matter, namely Pandurang Dattaraya versus Bar Council of Maharashtra, which is a case reported in 1984, the Supreme Court has held, and I quote, an advocate stands in a loco parentis towards the litigants. Therefore, he is expected to follow norms of professional ethics and try to protect the interests of his clients in relation to whom he occupies a position of trust. Now, you must have followed this carefully and kindly appreciate that there are two very important things which have been said in this paragraph by the Honorable Supreme Court. That an advocate stands in the position of a loco parentis, which I don't have to describe to you, but you will all understand the meaning of it. And therefore, he is expected to follow the norms of professional ethics. And also, he explains that the relationship between you and your client is that of a trust which you have to carry out. One more last quotation from the Supreme Court, which I would like to mention here, was in the case of Bar Council of Maharashtra versus D.V. Dabolkar. It is a bench of 7 honorable judges. And Justice Krishna here again, in his inimitable style, mentions, and I quote, the bar is not a private guild like that of a bakers, butchers, and candlestick makers, but by a bold contrast, a public institution committed to public justice and a pro bono publico service. The grant of a monopoly license to practice law is based on 3 assumptions. And I thought this is the entire gist of what we are talking today. And what are those 3 assumptions that he mentions? Let me bring them to your notice one by one. The first is there is a socially useful function for a lawyer to perform. So the work that you are doing is very much connected with the society and how the society grows, how you have to become socially useful. The second assumption quoted in the judgment is that the lawyer is a professional person who will perform that function. And third, very importantly, it is mentioned that the lawyer's performance as a professional person is regulated by himself, not more formally by the profession as a whole. the central function is nothing less than the administration of justice. Therefore, your duty, there is a lot of burden which you will carry on your shoulders as a lawyer. It is not simply a profession to earn money or to quickly earn money, as these days we find everybody is very keen to quickly earn money. And even when they look at some of the lawyers who are doing very well in the court, they assume that these lawyers probably landed up in the Supreme Court and they were doing as well as they are doing today. They forget that even lawyers like Ram Jethmalani, Fali Nariman, Soli Sorabji spent number of years in the high courts and in trial courts where they practiced day in and day out, and it is only thereafter that they could step into the Supreme Court. In fact, I would like to mention to you that when I joined the Supreme Court in the year 1975, for the first time, the 4-year rule was introduced for giving the examination. We were all very upset because before that, you could write the exam after 1 year of training with an advocate on record. And we made a lot of hue and cry, etc. But we were informed that the then Chief Justice was determined that if we make if we sort of are not happy with it, we were communicated that he was going to increase the period by 7 years. So we all backed out and waited for 4 years and did our practice and then wrote our exam after that rule was introduced. And today, I think it was a beneficial rule. It gave us chance to learn, to practice what was written in the Supreme Court rules, what was in the Bar Council of India rules. As I told you, the moment you start your practice, things were at that time very different. We paid very little attention to these rules. Even today, I know that these rules are somehow not that favorite of everybody, but they play a very important role in your life. And as I said earlier, every advocate has to live by his conscience, and you are a judge of yourself. Now, the Bar Council of India has framed several rules which you must have gone through. Of course, one of the foremost things that comes to my mind is that we all learn that today, because of the changing world and growth of technology, we have the assistance of laptops, we have assistance of internet, but still our rules which are provided in the Bar Council are very categorical and clear that you will not solicit, you cannot advertise directly or indirectly. And you are aware of the fact that they have given a certain manner in which you can even have a website, but you have to get it approved from the Bar Council and you have to adhere to the rules, the circulars regarding advertisement, communication, interviews, etc. So one very important feature that is regulating the lawyers is the Bar Council of India rules, which form the basis of how you have to conduct yourself as an advocate. we are very much aware of the fact that there has been an issue which has been lingering on in our profession for a very long time, which relates to strike by advocates. There are a number of cases which are decided by the Supreme Court because the problem has grown and it has happened repeatedly. And through these judgments, you have learned and you have to follow them. And what they really entail is that your rights end where the litigant's rights begin. So it is not only your rights which you are agitating by going on strike, which are important, but you cannot forget that once you file a wakalatnama, you are representing a client, and our system basically is meant for litigants. The Supreme Court or the High Courts or the trial courts, the judges, the staff, and the advocates, they are all there to assist the litigants in getting justice. So you have a duty and an obligation, in fact. Therefore, any unethical and unprofessional act on your part is not going to be successful, because administration of justice cannot be infringed. And you are a part of that. As I explained earlier also, that your role is basically in running of the administration of justice. It is not only the judges and the registry and the staff which carry out their duties from day to day. You have to perform a very essential part of your duty, which is to get justice delivered to your client by assisting the courts. There are only few exceptions, though. There are exceptions, and very intelligently, the courts have understood it very well. In rare of rarest cases, as you know, where dignity of the bar and integrity of the profession is involved, they have carved out exceptions. They have even prescribed a period, because lawyers' voice in the society carries a lot of weight, and democracy it's very essential for democracy that we have independence of judiciary. In fact, you are all helping the administration of justice, and whenever there is an event which strikes on the independence of judiciary, which is a rare of rarest case, and the dignity of the bar or integrity, then the courts have made an exception. The other important thing which I want to bring to your notice is that professional misconduct sometimes may also give rise to contempt of court. The Contempt of Court Act and the Supreme Court under Article 129 and also the Supreme Court under Article 142 have vast powers. In fact, there is a very famous case, a celebrated case, which I don't think I need to mention, But you are all aware where a lawyer was found guilty of criminal contempt because of his behavior in the court, which was in the High Court. The Supreme Court took up the matter by invoking its powers under Article 129 of the Constitution, read with Article 142 of the Constitution. Supreme Court categorically held that if there is a contempt in the face of the court, the Supreme Court has the power to protect the High Court from such a behavior. But we also have to keep in mind that in the Contempt of Court Act itself, fair and accurate reporting judicial proceedings will not be contempt. Fair criticism of judicial acts are not contempt. But again, as I said, it cannot be taken lightly. A lot of duty is cast on your shoulders. In fact, I am aware of a case where sometimes, and as I said, in this particular case, when I was in the court, the lawyer was very vehemently, aggressively arguing his case. And the court, after some time listening to him, said, there is no problem, you can go on, because it is your duty. But if you perform it within the Lakshman Rekha that is provided, we will only be assisted by you. There is also something very important which you all know, and which is the privilege that we advocates have with regard to the communication with your clients. Now just see how carefully that law has been made so that you and your clients can freely discuss the problems. The Evidence Act, as you know, provides that exception. But again, it is not an exception which will last forever. You have to be careful. As I said, your conscience should prevail in every difficult situation. And since you are taken upon the task of becoming advocates on record of the Supreme Court, it is a fact that you are not different from other advocates. But to assist the Supreme Court in discharge of its working, in delivering justice, your role is going to be very, very important. In fact, the courts are dependent on you. And I remember once basically I had committed I need not go in the detail. And inform the court that I was wrong in what has happened. The Honorable Court mentioned that since you are not a fly-by-night lawyer, and we know that you are devoted to this profession, that mistake was rectified by the court. I was mentioning the privileges. Just like the privileges that you have, which have been enshrined in a statute, there are also your duties. And as I mentioned earlier, your duties towards your client, towards the court, are clearly mentioned in the Bar Council of India rules. Please go through the same. And remember, it is not just for this exam that you are giving. It is something that you have to carry with you in your mind all the time. Because once you are a lawyer, it is not as if you are going to practice for a few days. In fact, there is no retirement age also. So it is also said that advocates are a very important part of the society, because the way you conduct yourself in the profession becomes your habit. And even if you are not a judge in the court, you are always providing solutions to your friends, to your neighbors, and society at large. And therefore, they all look up to you. And that is how you have to carry yourself. So, your duties towards the client and the court, please go through them carefully. It is another thing that which is very disturbing in our profession, which we all encounter. And that is the menace of some third parties who try to take advantage of our profession. And the rules categorically point out that if there are people who are not advocates and are trying to procure advocates by taking remuneration from clients, they have to be castigated as touts. You will find this menace and you have to deal with it. You have to overcome this problem as an officer of the court who is representing the clients who are in need of justice. I think I am not going to bring out each and every rule of the statute or the Supreme Court rules, which you can read yourself. But my purpose was to give you an overview of how you have to now conduct yourself. It's not only after this exam, but earlier also, before the exam also, you have been under training and you must have gone through sleepless nights, because this profession is a very demanding profession. It is easy, somehow relatively easy to enter the profession, but it is only your hard work with a lot of courage, grit and will, and following the rules and regulations that will bring success to you. So good luck to all of you. I think I don't want to say anything more at the moment. I think Kiranji is there now. Kiranji will take it further. Kiranji, over to you.
Thank you, sir. Mr. Datta has very eloquently pointed out what are the misconducts, professional misconduct, contempt of court act, strike, evidence act. So I'll not deal with that. Firstly, good evening to all of you. This is a paper, Advocacy and Professional Ethics. I'm sure all of you are looking for some hints. I'm not sure whether I'm going to give it or not. You have to catch it. It will be there in the lecture. You'll have to catch it. I will have my lecture in 5 sections. First, I'll tell what is the need of this paper. What is the importance? The second will be advocacy with reference to your duty towards the client. Third will be professional ethics with reference to your duties towards your client, court, opponent, colleagues, etc. Fourthly, special status which AOR have got in the Supreme Court. And lastly, our most celebrated 7 lamps of advocacy. The first is, what is the importance of this paper? I think this is the most important paper in the AOR exam. At the early stage of your life in the profession, you are reading Advocates Act, you are reading Bar Council of India rules to know what is misconduct, which you should not follow. What are the possible punishments? What are the possible defenses? You are also made to see Contempt of Court Act, that what type of conduct can amount to contempt of court, which you should avoid always. Then you have Evidence Act, which talks about confidentiality of the information given by your client, which you go through and you use it for whole of your life. And above all, you get into some professional dilemmas in your life, in the professional life, and this paper helps you to take the right decisions. The moment some professional dilemma comes, then you start thinking, yes, this is the ethic. I must follow it, and you take the right decisions. Other 3 papers may change, but basic duties of advocates in this profession and professional ethics and advocacy, that will not change. We may change the system, we may go to website, we may go to Instagram or Facebook, but our basic duties towards certain people will remain. And you will have only limited scope of publicizing. That's the importance of this paper, which will help you not only to become a good lawyer, but also to become a good person, for the reason that you are spending almost 12 to 15 hours in a day in this profession. If for 12 to 15 hours you are following ethics, you are bound to become a good person as well. So keep in mind the importance of this paper. Now I'll come to advocacy. My colleague has, Mr. Datta has already dealt with that you will have professional misconduct, etc. Now your duty starts the moment client approaches you. When your client approaches you, so you are at the SLP stage. Once it is SLP stage, at that point of time, you will have pleading. You will have documents, you will have evidence. You will also have the 2 or 3 judgments in your hand. You have to carefully go through the entire paper, all the papers, to come to the point how you can say that the impugned judgment is not correct. We have seen in the courts many a time judges asking that you say this is not correctly written in the impugned judgment, but have you taken this ground? If you have not taken, mostly you're out. Otherwise, maybe some liberty is given to file a review petition. But these are very important things. So you'll have to go through all the papers before drafting the SLP. I can't tell you about the drafting. That drafting persons will tell you. So far as advocacy is concerned, I will only tell that your synopsis, list of dates should be precise so that you can save the time of judicial time. There are 3 fundamental qualities which the client is looking from you. One is your utmost honesty. Secondly, your integrity. Thirdly, your diligence, which includes dedication and competence. Honesty, you're all aware, you have to be honest to your client. You have to tell everything, whatever you think is possible or not possible, so the client can take informed decision what he wants to do. Integrity is very important because we hear the sometimes instances where the advocate has not come up to the mark because he did not pursue the matter because of some extraneous circumstances or extraneous reasons. So integrity is very important for the client. And the third is diligence, that is your competence. It's not that when we get a case, we know everything about the case or the law. But we keep in mind that when you are filing SLP, you have to do sufficient research. That sufficient research can make you competent enough for that particular subject. And the moment you have that subject, get that competence, definitely you are bound to get some good audience, if not relief. So I will give you one or two examples. Like initially, when you file a suit for specific performance, somebody filed a suit for about 20 pages. And what was missing in that was readiness and willingness. We lost the case only on that count. So that these are small things which you could have known had you done enough research before filing of the case or before filing of SLP. At the same time, don't say no to a case because we are not judges. We are advocates. I remember an instance where, at the early stage of my career, thinking that I'm a very honest person, I told the client and advised him not to file SLP because there is nothing in your case. Client went off and somebody else filed the SLP. Notice was issued, stay was granted. So we cannot be the judges. So you don't know because every day we face surprises in the court. Then one instance case I really remember, it was a landlord-tenant case. I was appearing for the tenant for the petitioner. And that was the time when the court was looking at that if I have to give you 6 months time, I have to issue notice to the other side. I requested that you give me 6 months time. And he said, but I have to issue notice to the other side. I said, it's fine. Notice can be restricted to that. Notice was issued, restricted to whether 6 months time should be granted or not granted. And ultimately that case came up before the court after 7 years. We had nothing else but to smile. So you never know because court has taken us by surprises many of them. Therefore, don't take a decision. That is one part of advocacy. The second part of advocacy, because many times you don't get these second type in the books. You get it and learn it by observing, listening, and appearing in the courts. The first and foremost thing is that you should know your facts well. If you don't know law well, it can be still pardoned. And the court can give you time that look at the law and come back. But if you are not good at your facts, then probably you are not doing justice to your client and failing in your duty towards your client. Therefore, that is the first thing. Secondly, keep in mind that you are assisting the court in imparting justice. So your narration has to be accurate as far as possible. Thirdly, you have to keep in mind that when you're citing a case, you should not go only with the head notes. You read the head note and go and cite a case because head notes are many a times deceptive. Secondly, they are part of the paragraph. And if you see the entire paragraph, you will find that ultimately the case is against you. And sometimes you find in the court, judge is saying that this case is against you, you're citing it. One aspect you should always keep in mind is when the court has put a query to you, answer that query. Because if you don't answer that query, you're not going to get relief. Ultimately, judge is going to give relief. So you must answer that query as far as possible to the best of your ability. And then we always have but. So, but for some reason, we always explain later, but queries should be answered. That is the advocacy which you see in the court every now and then. It does not mean that you should not assert. You must assert. Be confident, argue with tenacity, so that you are doing complete justice to your client. And when I remember once Mr. Nariman saying that the best of the arguments we find is when after losing a case, we come out of the court. So assert as much as you can, be persuasive, because ultimately we are assisting the court to the administration of justice. So advocacy, firstly, the drafting part, getting information, getting yourself educated, then drafting, then appearance in the court. And also keep in mind that you have to do, your conduct has to be such that it doesn't put you to trouble. I know some case, somebody, I'm talking about earlier when I was not designated, somebody approached me to file a case in the consumer court. Then I said, fine. Then he asked me how much fees, court fees we have to pay. I said, consumer court, there is no court fee. He said, but when we came in the first round, we had paid about 2 lakhs court fee. Now I'm in a dilemma. There is some Milan Kumar. There is some this thing that Milan Kumar, please mute or something. So therefore, that is not even the misconduct. It is you are cheating the client. Now I had a dilemma whether I should expose that advocate who has taken 2 lakhs of rupees for the consumer court or not. Professional ethics, honesty, everything comes to my mind. But then I kept quiet. It was wrong, but then I did it. When I say, that's why I say, when you are dealing with this paper, you will find several occasions in your life when you will be debating between yourself what you are going to do. Now, next section, which I said, is the professional ethics. Professional ethics comes to you even before the client approaches you. Advocacy starts when the client approaches you, but professional ethics start even before they approach you. The first principle that you cannot advertise or solicit is before anybody is approaching you. We all know what is the advertisement, so it will be very it will not be very difficult for anybody to understand that. But soliciting is one area which is little which is debatable. In today's world, when we have website, we have Instagram, etc., we know many of the websites are having some information which they are not supposed to give. We are all keeping quiet. Bar Council, who is supposed to take so much action, is keeping quiet. Advocates are not bothered. I remember an instance which, of course, I would like to share with you. I was sitting in the court, a case of a very, it's a big case, and association, some senior advocate was sitting with me. He asked me a question. He said, which senior is appearing for you in this case? I told him my client has instructed not to engage any senior. Then he tells me, okay, please tell your client that I am ready to appear free for him. According to me, it's soliciting. But then my dilemma started. Whether should I tell it to my client or not tell it to my client? Or think it is a soliciting, I should avoid it. But then being honest person, I thought better tell to the client, let him take a decision. So I told the client that like this senior has told me that in case you approach him, he is going to do this case free for you. Client agreed straight away. Yes, let him do free. He is doing free. Why should I not avail his services? And we went to that senior's office and gave him the file, etc. After a couple of days, I was not there in the case. There was somebody else from their office who was in the case. Then again, dilemma came whether I should disclose it to somebody or not disclose it to somebody. I should file a complaint or not file a complaint. But I left it because it was word versus word. If it would have been definitely, I would have made a complaint. So therefore, soliciting is one area which comes to us even before the client approaches us. That's our duty, that we should avoid any such soliciting. Now, writing letters to the prospective clients. Today, WhatsApp to the prospective clients definitely is soliciting. But everybody is keeping quiet. I have hardly seen a case in which misconduct on the basis of soliciting has been punished or reported or punished. That is before. Now, next stage comes when client approaches you, but he has not hired you. When he comes to you, you're bound to accept his case. That's your duty. But at the same time, you are supposed to reject his case if he insists upon illegal means. Now your duty starts whether you should morally or legally accept the case or not. Because after hearing the client, you may find that there is some conflict of interest. Therefore, you cannot appear. But by that time, that client has already disclosed his confidential information to you. You have to maintain that, so you're blocked. You cannot appear for the other side because confidential information to you. Now, I remember a case in which one advocate, his uncle was a attesting witness to a will. He doesn't know because he came to profession much later. And the other side approached him. He filed the case and he was continuing with the case. Suddenly one day, the other side files an application that he is likely witness in the case because his uncle is dead and he's the only one who can identify the signatures. He has accepted the brief, he's continuing with the brief, but he's in a dilemma. What should I do? So you have to decide according to your conscience at that point of time. He decided to continue. He said, you can't block me like this. But that's his conscience. I would have left it. So therefore, these all are happening before even you are hired. Now, at that point of time, it is your duty to give fair advice. Fair advice is sometimes you should file SLP or not file SLP is not that you can always do because you don't know what's going to happen in the court. But like I said, taking court fee for the consumer case and asking them to file SLP against a review order which is not maintainable. These are the things which you should never do because this reflects your conduct. I remember a case in which one advocate who was standing outside the court, his case was being called inside, and ultimately on the second call, it was dismissed for non-prosecution. By chance, I knew the advocate. I thought when I came out, I told him, oh, your case is dismissed for non-prosecution. And I was surprised. He told me, I got it dismissed for non-prosecution because client has given me a meager fees. Now it is dismissed for non-prosecution. He will contact me. I'll get my balance of fees and make an application. method. We are all innovative. Advocates are very innovative to find their ways. But at the same time, our duties. Whether he has not complied with any of the duty, or it's only a method he has used. Decide. Now you have a next comes is you are hired. Now you are a duty to get the brief, unless there are special reason not to accept it. Then your duty towards court also starts. You have to maintain the status of dignity and decorum of the court. You have to act in a dignified manner, utmost respect to the court. Duty to assist the court by doing a proper research. But when you are appearing in the court, many times you will find that judge is not in your favor. No problem. And that is the time when your patience are tested. Your duties are tested towards the courts are tested. The court is against you. At that point of time, your behavior should be dignified, not only in your express words, but also in your conduct. Because the other day I was sitting in the court, somebody was losing the case, court was against him, and instead of saying anything, he made some gestures which court did not like. So your body language, even when it is against you, should not reflect any disrespectful to the court. That is your duty, because ultimately court is not stopping you from performing for your client. Your utmost duty towards client remains, but they are only saying be respectful. They have taken a view, right or wrong. That's not your business, because they have to impart the justice. Now, there are other duties of the advocates. I find now over the years, some of the traditions which we have been following are getting diminished. Number one, I find that when junior advocate comes to the court, asks for a passover, and he states, my senior is appearing in chief's court. Court asked, chief means what? Chief of Gunda, chief of gang, or what? You should say the Honorable Chief Justice of India. And our juniors using word yeah, I think we all have heard it. There was a time when even in the court, I remember Justice Kripal's court, one advocate was sitting with his body laid back, and Chief Justice Kripal told him that, look, you are not sitting in your drawing room, you are sitting in my court. Sit properly. So therefore, in the court premises, when we are all failing because we are not able to mentor our junior colleagues. One of the advocate they come for passover, they don't even know they are appearing for petitioner or respondent. Only thing they know is their senior's name is this, and therefore they need a passover. They hardly know what is the case, whether it's a civil case or a criminal case. Many of them, not all. So therefore, these are the things which we must mentor to our juniors. And one more disturbing factor which we find in the court is find that on last two seats, only interns and junior advocates are sitting. They are no problem in that. Most of them are concerned only with their mobiles, whether they are looking at social media or whether looking at a chat or whatever they are doing. They are pretending that they have not seen many seniors sitting around. So many seniors standing around. We had a tradition because we treat it as a family. that, okay, we'll give a seat to a senior. And that type of professional ethic, rather, we can say, which traditionally we followed and which is not there in Bar Council of India rules, I think we should continue. However big you may become, you have to follow the whatever law is. When you are looking at your mobile and not listening to the arguments or observing in the court, you have closed your one method of learning. And that's a very, very good method of learning. Now, you are all appearing for your exam. I'll be saying all the best to you later. But at the moment, I want to point out that Supreme Court as an institution has got great confidence on AOR system. They want AOR examination to continue. You have higher responsibilities than other advocates. You are the link, because you are supposed to have registered clerk, office within 16 kilometers, etc. Because you are the link between the client and the court, or client and the senior, client and the other opponent also. Therefore, it is very important for you to understand and realize your duties as advocate on record. Keep in mind that merely by signing the SLP papers, even for a friend, may land you in trouble. If you are signing, no idea, we also have signed for some friends, but see to it that you go through those papers before filing, so that you are not taken by surprise. Misconduct and strike, etc., while Mr. Datta has already dealt with. Now I'll come to the last portion of 7 Lamps of Advocacy by Justice Abbott Perry. Now, honesty, I have already told, honesty, integrity is very important in this profession, because you are there, somebody is trusting you with his life. You are helping somebody at the vulnerable positions, because he is one who is contacting you, trusting you fully. I will say, out of the 7 lamps, 1 lamp that is industry, that's very important for the advocate, which says hard work, hard work, hard work. There is, you know something of everything, but when you get a brief, you have to know everything of that thing. There is no alternative to hard work. That's the only way when you can protect your client. We used to have, at earlier point of time, wit was part of the professional careers, but now we find wit missing in the court. But 1 or 2 examples of wit which happened, they are true examples. One of the advocates came running to the court and started arguing a matter. And he says, oh, my client met with a fatal accident. And client said, okay, judges start listening to him, okay, fatal accident. Now, whether you have postmortem or something. He said, no, he met with a fatal accident. And thereafter, he was in the hospital for 2 months and then went home. So the learned judge said, okay, so fatal accident, he was in hospital and then went home. No, I understand your case. So that's how that person came running. One instance which I can't forget, one of the junior appearing for some senior, top senior in the court, And he says, my lord, I am seeking for Passover because my senior head so-and-so is passed away. And judge was taken by surprise. Passed away? Who? What? When? And he replies, my lord, just know he was here. Just know he has passed away. So these are some hilarious moments you get. And one more instance I remember, one of the senior appearing for some criminal case, probably he did not senior, some advocate on record. He did not have much of criminal cases probably. And he told his junior, you take IPC with you, etc., etc. He took IPC and thing. And then when asked him, okay, you come to section 310 of CRPC, he told his junior, give me CRPC. And that major acts, criminal law, criminal acts, he gave it to him. He said, I'm asking you criminal procedure code and you are giving me major acts. The judge was amused. He said, okay, please assist your senior to get criminal procedure code from this book. So many instances you get in the court where you feel that the persons who are appearing, they have not prepared themselves, which is absolutely not a correct way, because we are helping an administration of justice, but to the best of our ability. We cannot say that we can do everything, but yes, to the best of our ability, we should represent to the court. And make one more aspect which I want to mention is, in today's world, we have a lot of mediation and conciliations going on. Our duties even increase. So we have to keep our change of situations in mind. We must keep in mind the social media. And there's a question mark in my mind as to when we see in the website, that certain website and even Instagram, etc., that some of certain things are written which are contrary to and not in accordance with the duties or of soliciting or advertising. There's no reporting. I don't know when it will happen, but maybe soon. Bar Council of India wakes up and these things do happen. At the end, I will definitely say that in the lecture, I have given hints of the paper, what you are going to get. Some of the hints I have given. Of course, not all. I'm sure you must have caught some of them. With this, I will say all the best to all of you. I'm sorry I've taken 5 to 7 minutes extra, but thank you very much for hearing me, and all the best to you. Over to Mr. Datta.
Thank you. That was wonderful listening to you, and I'm sure everybody must have caught a lot of your during your speech. A lot they must have caught on. But anyway, they have to do that only, and that's the purpose of this lecture also. But before we close, I have one request to make to all the participants. We have often come across certain problems when we correct your papers. So one thing I request all of you, please write neatly. I know it is a little difficult at this stage because we have given up the habit of writing. But I'm sure, I think in your the beginning of your career and even today, you are still doing some writing. So please write legibly. And also, the next thing I want to share with you is that when you go through the question paper, you people must have appeared in several examinations by now. So you must be thinking, what is this they are telling us? This is very ordinary thing. But I must request you that you may go through the entire paper, and then when you start writing, we have noticed that in the first one or two answers that people give, they go on writing and they give very detailed answers, and subsequently when they deal with the other questions, they find the time is very short. So those questions, so you have to divide your time accordingly. Please do that. That is very, very essential. And of course, we all wish you a lot of luck. And as already stated, your main task after you become advocates on record, a lot of burden will be on your shoulders to assist the Supreme Court. And we all know the importance of the Supreme Court. And as I said, some of you will have more work, some of you will have less work. Please do not ever indulge in any of the wrong or sharp practices, because I was told by a senior very clearly in the beginning of my career that this is a marathon race, as I told you. It is something that you have to run for a very long time. And it is not a sprint, it is not a 100-meter dash that you have to finish in a few days. Read, read as much as you can. Not only law, you can read other subjects also, because a lawyer has, as it is said in the Raymond's ad, a lawyer is a complete man. And with all humility, I now request the office to bring this to an end. Thank you very much. All the best to all of you.
Thank you, sir. Thank you, ma'am.
Thank you.
sir. Thank you, ma'am.
Thank you, sir.